Good day. My name is Anton Levkov, and today I want to tell you about how to apply for bankruptcy and who is entitled to do so. Both the citizen himself and his creditors and the authorized body have the right to file for the bankruptcy of the citizen. In bankruptcy law, a separate creditor is distinguished, a creditor for alimony. What do I need to file for bankruptcy? A citizen has the ability to file for their own bankruptcy without any preliminary actions, which I will provide information about a little later. And the creditor, the authorized body and the creditor, including the department, must first sue their debt for this. So, the concept is to obtain the abilities to retrieve financial resources from this individual who owes money. And this decision must definitely yield to the force of law. And one more important clarification is that the debt must be overdue for over 3 months. This implies that the deadline established by the agreement for meeting the responsibility, specifically for making the payment, needs to be past due by a minimum of 3 months. If it's less than 3 months overdue, it won't let you down. I want to clarify that we're not talking about 3 months from the decision becoming legally binding, but rather 3 months from the contractual deadline for fulfilling the obligation, which is when the debt should have been paid according to the terms of the contract. In the event that a citizen decides to file for bankruptcy, the minimum required amount of debt must be at least 500,000 rubles. Key clarification. In the same case, if a citizen files for bankruptcy, their debt may be as low as 100 rubles, but not economically beneficial. So, a citizen is not limited in the amount from which he can personally file for his bankruptcy. Only credit cards are restricted by this specific amount. I would like to specifically emphasize that we have responsibilities, such as obligations that arise from a contractual agreement for a bank loan. There is no presence. If the obligation arises from a loan agreement with a bank, then the creditor of the bank has the right to choose not to provide services for this debt. Therefore, he possesses the right to promptly initiate a bankruptcy claim through the court, while presenting substantiating evidence of himself and God's involvement. I would like to point out separately in connection with this that we are talking about contracts for bank loans. In the event that the bank sells the debt to a collector, the collectors also retain this right. However, if the bank has acquired rights to the debtor's claims under other obligations, such as a lease agreement or for heat supply or something like that, then the bank is subject to the general procedure for consideration. This means that the bank must follow the standard process for evaluating and addressing the debtor's claims. And I would also like to express that such an order will take place, and dear friends are very happy and excited to see you. Please do not hesitate to come and contact us, as we are always ready and available to help you. It was a pleasant morning spent with a lawyer and Anton Azkov, and we look forward to hearing from you soon.